Okay, we are live. Hello, good evening, and welcome back to the Law Entrance YouTube channel. We are back with another session of legal reasoning today. And today we'll be taking the next step in understanding how to solve legal reasoning questions, specifically passage based questions. In the previous class, we looked at how to approach the legal reasoning section, what are some important things to remember, and then we also practiced some short questions. Which were like one paragraph and one question, few sentences, then one question. But in today's class, we are going to solve actual passage based questions, which are closer to the actual CLAT and ALET pattern, not ALET, specifically CLAT pattern. And let's see how it goes. So, this is, you could say, one of the last introductory classes. And beyond this, we would be starting our subject wise preparation. We would most likely start with law of contracts first, or either law of torts. We'll see next week. But for now, this is, you could say, the final leg of your introductory classes of introduction to legal reasoning as a subject. And yeah, that's the plan for today. Practicing few questions, revisiting some important points which you need to keep in mind while solving legal reasoning questions, and practicing questions. Priyanshi is here, Anusha is here, Udit is here. Very good evening, guys. Good evening. Welcome to the class. Chalo, start karte hain without any further delay. Let me just quickly present my screen with you all. Udit is saying afternoon Menti quiz kept showing connection timeout. That's why I left. Could have been a technical glitch on your end. That's okay. Happens sometimes. Maybe next time you can participate. You can anyway watch the recording of the session for the questions. 2x पे देख लेना उसको so that you don't miss out on the questions. बाकी अब तो हर फ्राइडे करेंगे हम मेंटी क्विज, so there is nothing to worry about. ठीक है जी, चलो. Let's begin today's session on legal reasoning. Now, legal reasoning, as you all understand, is a very important component of the CLAT exam, and इसको अच्छे से करना is very important because this is a very scoring section. Most of the time, legal reasoning section is one of the easier sections. Maximum cases में medium होता है. बहुत कम ऐसा देखा गया CLAT papers में कि legal reasoning has been very tough or very complicated. Mostly it's very doable in the CLAT exam. CLAT exam के अगर आप past year papers देखोगे तो वो भी बहुत आपको simple लगेंगे if you are well versed with how the questions go. So let's start with our discussion. सबसे पहले, what are principal fact based questions? We'll understand that. Then some important points to remember, and then we'll practice a few questions. अगर time बचता है तो we'll do 2 passages, वरना एक passage तो हम definitely आज करेंगे ही करेंगे. ठीक है, so that's the agenda for the day. So सबसे पहले बात करते हैं what exactly are principal fact based questions. Although we discussed this in the previous class, but just to reiterate, just to revise, just to recap, principles are your legal principles, which could be derived from actual laws, which could be derived from actual statutes, actual provisions of the Indian Constitution. Primarily 4 major legal subjects जो हैं हम पढ़ेंगे in the course of next few months. But ऐसा नहीं है कि हमारे जो passages होंगे, हमारे जो questions होंगे would be restricted to those 4 pillars. कौन से पिलर्स की मैं बात कर रहा हूँ? मैं कर रहा हूँ बात लॉ ऑफ टॉर्ट्स की, मैं कर रहा हूँ बात लॉ ऑफ कॉन्ट्रैक्ट्स की, मैं कर रहा हूँ बात आपका लॉ ऑफ क्राइम की, एंड मैं कर रहा हूँ बात आपका कॉन्स्टिट्यूशनल लॉ की. So these are the 4 pillars which we'll be studying in the next few months as a part of our syllabus. But beyond that, there can be multiple other areas of law जहाँ पे questions can be framed. It could be the IT Act or technology related laws. It could be family law related questions. It could be corporate law related questions. It could be any miscellaneous sort of questions. It could be questions based on recent judgments. So make sure you guys follow important legal judgments which are highlighted in the news as well. Good websites to follow them would be livelaw.com और barandbench.com. आपको सारे जजमेंट्स नहीं फॉलो करने, जो बहुत ज़्यादा इंपॉर्टेंट हैं, जो नेशनल न्यूज़ में आते हैं, वही वाले फॉलो करने. मोस्टली मैं आपको बता ही दूंगा अगर कोई ऐसा होगा तो. ठीक है. Now, coming back to what are principal fact-based questions. Principles, as we just discussed, are rules. Principles are laws. Principles are something which is derived from actual law. ठीक है. Now, principle in our case, when we are solving questions, could also be sentences which, although look like a law, but might be different from an actual law. What I mean is, मैंने आपको पिछली क्लास में भी एग्जांपल दिया था कि if your principle says that murder is not a crime, so would you believe that principle? The answer is yes. Whatever the principle says, you have to believe that blindly, even if it does not match your commonsensical understanding, even if it does not match the रियल वर्ल्ड सिनेरियो. और आपको अज्यूम नहीं करना है कि हम इंडिया की बात कर रहे हैं या फिर हम रियल वर्ल्ड सिनेरियो की बात कर रहे हैं. आपको अपने सारे बायसेस, सारी प्रायर नॉलेज साइड पे रखनी है इन लीगल रीजनिंग क्वेश्चंस. ठीक है, principle is always correct. You have to just stick to the principle, follow the principle, and answer your fact based questions based on the principle. So that is the first point to remember as well. The second point to remember is the option which is closest to your principle, or in this context closest to your passage, has a better chance of being the right answer. Whereas on the other hand, options which are, let's say, talking about something very different on a different tangent, which are out of scope, which are irrelevant, are usually not the correct answers. Also, another point to remember is if you are stuck between two, let's say two options, A and B, and you have eliminated C and D, a good way to judge between option A and B is which one of them is more aligned with the principle, or which one of them is more elaborate इन कॉन्टेक्स्ट टू द प्रिंसिपल. हो सकता है दोनों में सेम बात लिखी हो, लेकिन ए में थोड़ा सा उसको बेटर इलेबोरेट और डिस्क्राइब किया गया हो. इन दैट केस ए वुड बी योर बेटर ऑप्शन बिकॉज इट गिव्स यू मोर कॉन्टेक्स्ट, राइट. जो बेसिक रूल्स हैं कि एक्सट्रीम ऑप्शन से हम थोड़ा सा दूर रहेंगे, इररेलेवेंट ऑप्शन से हम थोड़ा सा दूर रहेंगे, ऑल ऑफ दोज रूल्स ऑल्सो अप्लाई टू लीगल रीजनिंग क्वेश्चंस. एंड उसके अलावा यही है बस कि प्री कंसीव्ड आपको कुछ भी अज्यूम करके नहीं चलना. जस्ट स्टिक टू द प्रिंसिपल, स्टिक टू द फैक्ट्स एंड ट्राई टू लॉजिकली लिंक देम. दैट्स ऑल यू नीड टू डू. ठीक है, समवन विद lesser legal knowledge or no legal knowledge can also solve these type of questions because they are more of a logical reasoning based questions rather than legal reasoning based questions. क्योंकि you're not expected to know everything in the law, right? वो आप लॉ स्कूल में सीखोगे. अभी आपको एक्सपेक्टेड क्या है as a law aspirant, that how well can you understand the law and how well can you apply the law to a given set of facts. ठीक है, so that is the purpose of these questions as well. That being said, if all of that is clear, let's start practicing some questions. I hope everything I was discussing is clear to everyone and we are ready to solve questions. Priyanshi, Udit, Anusha, all of those guys. Priyanshi saying, I saw a legal passage about Muslim law regarding divorce. It boggled my mind a lot. It's okay. You don't need to know all the laws, to be honest. You don't need to even understand all the laws. You're not expected that at this particular stage. बट हाँ, कभी कभी ऐसा होगा दैट यू वुड एनकाउंटर पैसेजेस और लॉज विच आर कॉम्प्लिकेटेड टू अंडरस्टैंड, विच आर डिफिकल्ट टू understand. That's okay, that's completely understandable. You guys are not lawyers as of now. Just try to get better with practice. Just try to know the basics and use your logical brain. That's all what matters. Okay, now let's start solving some practice questions. We'll do a passage based question. If we are able to do the first passage in time, we can also solve another second passage. So let's begin. So the rules for this would be simple. The instructions are that when you encounter a passage in the legal reasoning section, it is a good practice to read the passage first. Now this goes opposite to my advice of the RC section, the English section, or the logical reasoning section, where I advise students to read the questions first. आपने देखा होगा जब हम प्रैक्टिस भी करते हैं LR के क्वेश्चंस की या इंग्लिश के क्वेश्चंस की, तो मैं एक जल्दी से ओवरव्यू लेता हूँ आप लोगों के साथ क्वेश्चंस का, जिसमें हम क्वेश्चंस को पढ़ते हैं, है ना, एंड देन वी डिसाइड कि कौन सा क्वेश्चन हम पहले अटेम्प्ट करेंगे. अब इसमें भी आप क्वेश्चंस को पढ़ सकते हो, बट इसमें उतना प्रोडक्टिव वो नहीं रहता एक्सरसाइज, बिकॉज two reasons. One is the questions are sometimes lengthy and the options are also lengthy, so उसमें थोड़ा सा डबल टाइम वेस्ट हो जाता है. एंड सेकेंडली, जब तक आपके पास कॉन्टेक्स्ट नहीं होगा आप समझ नहीं पाओगे क्वेश्चन बात क्या कर रहा है. सो इट्स बेटर टू हैव कॉन्टेक्स्ट and having read the passage and then attempting the questions. ठीक है, so इसमें I would suggest कि passage first approach आप लोग use करो, unless it is something which you already know. अगर मान लो कॉन्ट्रैक्ट पे आ जाता है और आपको पॉइंटर्स में ऊपर ऊपर दिख रहा है कि हाँ दिस इज समथिंग विच इज रिलेटेड टू द इंडियन कॉन्ट्रैक्ट एक्ट, तब आप प्रॉबेबली क्वेश्चंस की तरफ जंप कर सकते हो एंड देन कैन रेफर बैक टू द पैसेज फॉर हेल्प. बट इन मोस्ट केसेस आई वुड एडवाइस कि पैसेज पहले अच्छे से पढ़ लो, उसको समझ लो, देन मूव टू द क्वेश्चंस, क्योंकि इस बार इसमें क्वेश्चंस भी डिफरेंट डिफरेंट फैक्ट सिनेरियोज होते हैं, सो यू हैव टू बी वेरी केयरफुल अबाउट देम. ठीक है. That being said, let's start practicing questions. Let's move to the first passage. So this is the first passage. I would give you guys 30 seconds to read this passage. Then we'll attempt 6 7 questions based on this passage. Just give me a done in the chat box when you guys are done reading the passage. Okay, Priyanshi is done, Udit is done, Anusha is done, Rudra is done, Adarsh is done. ठीक है, चलो, let's move to questions then, guys. This is the first question. Okay, Priyanshi says it would be option number D. What about the rest of you? Anusha says it's gonna be A. Okay, I'm waiting for the responses. Rudra, Udit, Rudra says B. Okay, ठीक है, चलो, let's check. Let's read the question. After a divorce, Rahul seeks custody of his 10-year-old daughter, citing that he is the primary caregiver as his ex-wife Anita often travels for work. Anita argues that she provides a more financially stable home. What factors will the court prioritize in deciding the custody of the daughter? Now, you don't have to answer it based on what you think. You have to answer it based on what is given in the principle. Let's read the principle or the passage in this context. The paramount consideration, that means the topmost consideration in any custody dispute, is the welfare of the child. ठीक है? Which includes ensuring their emotional, educational, and physical well being. Okay. Courts typically favor the primary caregiver in custody. Who's the primary caregiver here? Rahul. But they also consider the child's preferences if they are old enough to express a reasoned choice. So, if let's say the child is, for example, 20 years old, that means he is almost old enough to express a reasonable choice. Now, let's look at our options. Rahul's role as the primary caregiver, would that be a deciding factor in the custody? Yes, absolutely. Anita's financial stability, is it mentioned anywhere that financial stability has to be ensured? Emotional, yes. Educational, yes. Physical well being, yes. But financial stability has not been mentioned explicitly. So, not a very strong option for us. Child's preference, assuming she is capable of making a reasoned choice. Has that been mentioned in the principle? Also, yes. Child's preferences if they are old enough to express a reasoned choice. So, both A and C are correct in this context, which makes option D to be the correct choice because it says both A and C are equally prioritized, right? That is what the principle also says. So, option D is the correct answer. Got it, guys? Understood? Why not A but also option C? Because it's mentioned in the principle. They also consider this. Typically favor this, but also consider this. That means both of them have equal sort of weightage, equal priority. Okay, so option D is the correct answer for question number 1. Let's do question number 2. Anusha is saying, sir, but isn't she too young to make a choice? How would you assume that? How do you assume 10 is too young to make a reasoned choice? In the eyes of the court, based on what the child's response is and her understanding is, she might be reasonably giving an opinion that why she wants to stay with her father or with her mother. So you cannot really make assumptions. The principle does not say that the child has to be at least 15 years old or 20 years old. Even a 10-year-old child can make a reasonable, choice. So we won't be assuming that. And also, when you look at the option, it says that assuming she is capable of making a reasoned choice. So it lies on an assumption, right? They're not saying that she can make a reasonable choice. They're saying assuming she is capable of making a reasonable choice. Okay, that's why. So, question number 2, we have responses. Most of you have responded B, which seems to be the correct answer to me as well. Manav and Priya are getting divorced. Both want sole custody of their son. Priya has accused Manav of neglect, but has no substantial proof. Manav requests a joint custody arrangement. How might the court likely rule based on the accusations and request for joint custody? अब देखो accusation proof तो हुआ नहीं है. So let's read the principle. Joint custody arrangements have become more common, reflecting a modern understanding of parenting and child welfare. It allows both parents to share legal and physical custody, enabling the child to maintain a strong relationship with both. Specific terms are often customized to meet the unique needs of child and the logistical and emotional capabilities of the parents. Now, Priya has accused Manav of neglect but has no substantial proof. So, if she has no substantial proof, joint custody is the way to go, right? In case a parent is deemed unfit due to reasons such as abuse, neglect, or incapacity, sole custody may be awarded. Again, it's maybe and it is when proven, right? So it's not proven, but therefore it would be option number B, that grant joint custody as it allows the child to maintain strong relationship with both parents. It would not be awarding sole custody to Priya or to Manav, or delay the decision until further evidence is presented. It's going to be option number B. So well done, guys. Good job. Right answer. Let's do question number 3. Okay, most of you have answered option number C. Let's check. What does the author imply about the role of grandparents in child custody situations? Grandparents and other close relatives can also seek custody under certain circumstances, especially if it is in the best interest of the child. They are often the best choice for gaining custody. No, they should be considered if both parents are deemed unfit. Maybe they can seek custody if it's in the best interest of the child. Yes, that is closest to the principle. Their rights are secondary to the parents' rights. That's irrelevant. So, closest to the principle is option number C, which is the correct answer. So, good answer. Well answered. Good job. Let's move to the next one. Question number 4. Okay, some of you say A, some of you say B. Let's check. Based on the author's discussion, what legislative change might the author support regarding child custody laws? Okay, let's see. These principles are not just theoretical but are actively implied in numerous cases where the court's intervention is necessary to resolve disputes regarding the upbringing, guardianship of the child, post divorce, or separation. The legal framework aims to balance the rights of the parents with the best interest of the child, often leading to tailored custodial arrangements that serve to nurture the child's overall development. Stricter requirements for providing parental unfitness. Maybe more flexible custody arrangements to adapt to a unique family situations. See, he is also talking about tailored custodial arrangements to serve the child's overall development. So this is more aligned with the principle, option number B. Definitive age at which child can choose their custodial parent. Not really. Increased penalties for false accusations. He is not talking about that. So based on the author's discussion, this seems to be the most valid option which he would support, that we should have tailored custodial arrangements or flexible custody arrangements to adapt to unique situations, right, which are in the best interest of the child. So option B is the correct answer for question number 4. Okay, because it's closest to the principle. All right, let's move to the next one. Question number 5. Isn't he saying flexible custody is already practiced in law framework? चलो देखो. What legislative change might the author support? ठीक है. नहीं, ऐसा नहीं लिखा है. It aims to balance the right, often leading to tailored custodial arrangements. So it's still an aim. It's not a legislative change, right? It is not a law per se. It is a aspiration. It is an aim. It is a goal कि ऐसा होना चाहिए. So that is why he would be, speaking in favor of such a legislative change. Legislative change मतलब change in the legislation, change in the Guardians and Wards Act of 1890. Abhi we are saying we are just aiming for this, right? That is why. Okay, chalo. Let's do question number 5. Priyanshi says B, Udit says D, Rudra says B, Anusha says D. So we have two responses for B, two responses for D. Okay. All right, let's look at the question. Considering the author's emphasis on the best interest of the child, what might the author suggest is the most crucial in custody cases? Ensuring the child's financial needs are met, evaluating the emotional and physical care the child receives, balancing the logistical needs of the parents. See, A and C are definitely no. Maintaining the status quo of the child's life. Has the author really emphasized upon the status quo? Is there any mention of maintaining the same status of the child? Not really. Terms customized for the unique need of the child, logistical and emotional capabilities of the parents. Even this is mentioned, but option number D, is that mentioned? Not really. We're not talking about status quo anywhere. So I believe when you look at the proximity with the paragraph, option B is the closest. Emotional and physical care of the child is right up there. It includes emotional, educational, and physical well being of the child. Paramount consideration, the top most consideration. एंड यहाँ पे भी मोस्ट क्रूशियल पूछा है तो मोस्ट क्रूशियल लॉजिस्टिकल नीड्स तो नहीं हो सकती फाइनेंशियल नीड भी नहीं हो सकती मोस्ट क्रूशियल क्या होगा इमोशनल एंड फिजिकल केयर सो दैट मीन्स ऑप्शन नंबर बी टू बी द करेक्ट आंसर ओके बी सेज इवेल्युएटिंग हाँ इवेल्युएट ठीक है इवेल्युएट करेंगे तभी तो आप इंश्योर कर पाओगे कि वो रिसीव होगा कि नहीं इवेल्युएटिंग द इमोशनल एंड फिजिकल केयर द चाइल्ड रिसीव्स भी तो लिखा है कि देखना कि क्या उसको सही फिजिकल एंड इमोशनल केयर मिल रही है कि नहीं यहाँ पे मेट लिखा है यहाँ पे मेंटेनिंग लिखा है यहाँ पे बैलेंसिंग लिखा है यहाँ पे रिसीव्स लिखा है सो इवेल्युएटिंग तो सही है यू इवेल्युएट एंड देन द चाइल्ड रिसीव्स दैट्स नॉट एन इशू ठीक है all right question number 6 and 7 okay last two questions for the day okay Rudra says C Anusha says A Adarsh says C Priyanshi says A all right so both the females have chosen option A and both the males have chosen option C interesting okay so we are waiting for Udit's answer let's read the question Nina and Suresh are divorcing and both are capable caregivers. Their 12-year-old son expresses a preference to live with Nina because she lives closer to his school and friends. Okay. Suresh argues that he has a more flexible work schedule and can spend more time with him. Considering the child's age and preference, along with the factors presented by both parents, how might the court decide? Okay. So we have multiple factors. One is this in, ensuring emotional, educational, and physical well-being. All right. Then there it is written, court typically favors the primary caregiver in custody. Who is going to be the primary caregiver? The one who can spend more time with the child, right? So that's gonna be Suresh. But we also want to consider the child's preferences. What is the child preference? The child's preference is Nina. So if both have to be balanced, which one are we going to choose? We have to strike a balance between both the custodies. Suresh or Nina or the joint custody? Joint custody. because it would have benefit for both the parents if they share legal and physical custody, and the child would have a good relationship with both. ठीक है, ऐसा तो नहीं है सुरेश के साथ रहने से कोई लॉजिस्टिकल एंड इमोशनल नीड फुलफिल नहीं हो रही, या नीना के साथ रहने से वाइस वर्सा ऑल्सो. So joint custody is the best arrangement in this particular case because Nina also has a valid case and Suresh also has a valid case based on the principle. One is the primary caregiver and one is the child's preference. So you have to balance both of them. Okay? That is why we would order a joint custody, splitting time between both the parents. Okay, and not just give it to Nina because of child social stability and schooling proximity. Those are not the factors which we are relying on. The factors are emotional, educational, and physical well being. And both of these factors are not really aligning with this. Although we can say that the child's preference is has to be taken into account. So that is why joint custody is the best way to go. Okay, got it? I hope this is clear. All right, let's move to the last question of the day. This is a simple one. Right, most of you got this right. All of these are valid factors to be considered while giving custody. So that is why the option would be all of the above. That is the right answer. So that brings us to the end of this particular session. I hope you all got a little taste of how do we look at passage-based questions, paragraph-based questions, and how do we apply the given principles to a given fact scenario, and how there can be multiple variations, how we need to align with the principle, choose the option which is closest to the principle, reading the facts carefully. This is all what we have to do. And with the next particular session, we would be beginning with our subject wise study, most likely law of torts. So, yeah, that's the plan. That's all for today's class. Thank you so much for attending and participating. I hope this was productive. I'll see you all in the next class, which would happen on Monday, 3 p.m., the Hindu analysis. Till then, have a great weekend. Tata, bye bye. Take care. Keep learning, keep preparing. Signing off. Bye bye. No, Priyanshi. As of now, I don't teach in the offline centers. I teach in the online batches. Okay. Chalo. Bye bye, guys. Take care.